Hi, my name is Dave Furman, and I'm a judge on the Colorado Court of Appeals.
My name is Steve Bernard, and I'm a judge on the Colorado Court of Appeals, too.
It has been said that appellate judges watch from on high the legal battle fought below, and when the dust and smoke of the battle clears, they come down out of the hills and shoot the wounded. Well, hopefully we can avoid you feeling that way. We're here today to talk with you about what our court does and offer some tips about some issues that have led to trial court judgments getting reversed.
What is your role as a trial court judge? In a nutshell, you make findings of fact, reach conclusions of law, manage the proceedings, and ensure that they're fair.
What is our role on an appellate court? We're an error-correcting court. We decide whether there have been any legal mistakes that undercut the fairness of the proceedings.
We think that the trial courts in Colorado do an excellent job. We are always impressed by how busy you are, how hard you work, how thoughtful you are, and how you consistently make the right decisions, even in really hard cases, in the very little time that you have to make them.
Well, let's take a few minutes to talk about how we on the Court of Appeals look at your decisions. We apply different kinds of review to different kinds of issues.
What is de novo review? De novo means new, fresh, a second time. For example, we apply this type of review when we interpret a statute.
What is clear error review? We apply this type of review when we review a trial court's factual findings. A finding of fact is clearly erroneous when it is not supported by substantial evidence in the record as a whole.
What is abuse of discretion review? For example, we apply this type of review when we review a trial court's decision to admit certain evidence at trial. Discretion means that the court has the power to choose between two or more courses of action, so it therefore is not bound in all cases to choose one over the other. I'd like to use a metaphor about an enclosed pasture in talking about this kind of review. Imagine that you have an enclosed pasture and you have some dairy cattle in it. It's a hot day. In one corner of the pasture is a grove of trees. In another corner of the pasture is a pond. If you were to decide to take your cattle to the trees to shade them, it would not be an abuse of discretion not to take them to the pond, because both would be reasonable. But if you decided to take the cattle outside of the pasture and go down to your neighbor's pond and drink your neighbor's water, that would probably be an abuse of discretion because you don't have the right to be on the neighbor's property.
Appellate courts defer to trial courts' credibility findings. We are not where you are. We don't see a witness, so we can't evaluate the witness's demeanor.
It is important that you make a clear record of your factual findings and your legal conclusions. We cannot effectively review your decisions if you don't. This record does not have to be long or complicated. Indeed, it can be a single sentence. But it is important that you let us know why you reached the decision. In this vein, my favorite word in the English language is because. If you give us a because, then we understand why you did what you did. If you want more in-depth advice about making a record, please consult the video in this series that is specifically dedicated to that subject.
What is plain error review? We apply this type of review when a defendant has not preserved a contention by making a contemporaneous objection in the trial court. Although a defendant did not object, an appellate court will reverse a conviction if it concludes that an error is plain. That means that the error must be obvious, substantial, and that it so undermined the trial's fairness that it casts serious doubt on the reliability of the conviction.
There are certain situations in which we will not reverse a judgment, even though we have concluded that there was an error.
One of these situations is called invited error. Parties may not complain on appeal about errors that they have injected into the case. Invited error most frequently occurs when a defendant tenders an instruction that the court later gives to the jury, or agrees to an instruction that the court later gives to the jury. In situations in which it is unclear what defense counsel wants to do, it's okay to ask them, do you agree or disagree with this?
What if the error is harmless? In other words, we do not reverse convictions if the error did not prejudice defendants or their cases.
Here are a few areas where, over the past several years, we have seen opinions reversing trial courts. What about defendants who want to represent themselves? Competent defendants have a constitutional right to represent themselves, but a pro se defendant may not do a good job of being his or her own lawyer. The Supreme Court has set forth 14 questions to ask in cases in which defendants want to represent themselves, in the appendix to People v. Arguello. In applying this test, remember that indigent defendants do not have an unlimited right to particular public defenders or appointed counsel. Arguello also discusses what to do when a defendant makes a request for a new lawyer on the eve of trial. And if you rule on a motion for a continuance to allow a defendant to hire the attorney of his or her choice, be sure you address all 11 factors found in our Supreme Court's 2014 decision of People v. Brown.
Another place that we sometimes find reversible error is in pretrial motions hearings. Sometimes a trial court will not make adequate factual findings or reach legal conclusions that apply the right law. Suppression issues are often mixed questions of law and fact. One way that you can avoid this problem is to put together a pretrial motions notebook that contains the relevant tests for different kinds of motions. This notebook should lay out the burdens of the defendant and the prosecution and describe the factors that apply to pertinent issues. Here is just one of many, many examples. Let's say that the defendant has filed a motion to suppress an out-of-court identification by a witness who looked at a photographic lineup. What is the relevant legal concept? A defendant is denied due process when an in-court identification is based on an out-of-court identification that was so suggestive that the in-court identification is unreliable. Who bears the burden? The defendant must first show that the photographic array was impermissibly suggestive. If the defendant does not satisfy this burden, then the court denies the motion. But there are factors that figure into analyzing the array, including the size of the array, how the officer presented it, and the details of the photographs. Just for one example, when considering all of the photographs, is the photograph of the defendant the only one that matches the description of the perpetrator? But if the defendant shows that the array was impermissibly suggestive, then the out-of-court identification is inadmissible, and the burden then shifts to the prosecution to show that the witness's upcoming identification during trial will be reliable under the totality of the circumstances. Factors that figure into analyzing the reliability of in-court identifications include the witness's opportunity to view the perpetrator, the witness's degree of attention, the accuracy of the witness's previous description of the perpetrator, the witness's certainty at the time of the confrontation, and the length of time between the crime and the confrontation. The court weighs the corrupting effect of the suggesting identification against these factors.
Let's talk about jury selection. What should be in your record when, for example, you grant or deny a challenge for cause? You should give a reason, including if that reason is based on your personal observation of how the juror responded or did not respond to questioning. What if you get ping-pong jurors who tell the prosecutor that they can be fair, then tell defense counsel that they can't be fair, and then, when rehabilitated by the prosecutor, flip again? Remember that there is a difference between a juror who might not be able to be fair and one who has simply been confused by an awkward or compound question asked by the prosecutor or defense counsel. What about Batson challenges? These challenges are based on an allegation that the prosecutor or defense counsel exercised a peremptory challenge to remove a prospective juror from a jury for constitutionally impermissible reasons, such as race, ethnicity, or sex. You must resolve up to 3 questions. First, did the opponent of the challenge present enough evidence to establish a prima facie case of discrimination, meaning an inference that discrimination occurred? If you answer this question no, then you're done. But if you answer this question yes, you must next evaluate the reason for the challenge that the proponent of the challenge gives. The reason need not be plausible or persuasive as long as it is facially neutral. The opponent of the challenge must be given an opportunity to rebut this explanation. The court then looks at all the evidence and determines whether the opponent of the challenge has proven, by a preponderance of the evidence, that the proponent made the challenge for a discriminatory reason. State your reasons on the record. We review this factual finding for clear error.
Just like putting together a pretrial motions bench book, it's a good idea to put together an evidence notebook for trial. For example, when can a party impeach a witness with a prior inconsistent statement? Or what sorts of out-of-court statements are or are not hearsay? Let's talk about a particular evidentiary issue that sometimes results in the reversal of a conviction, the use of uncharged misconduct evidence under Colorado Rule of Evidence 404B. Our Supreme Court's decision in People v. Spoto sets out a four-part test to determine whether evidence of uncharged misconduct is admissible. First, does the uncharged misconduct relate to a material fact? A material fact is of consequence to the action. Second, is the uncharged misconduct logically relevant to the material fact? In other words, does the uncharged misconduct have any tendency to make the existence of the material fact more probable or less probable than it would be without the evidence? Third, is the logical relevance of the evidence independent of the prohibited intermediate inference that the defendant committed crimes because he or she acted consistently with his or her bad character? And fourth, is the probative value of the uncharged misconduct substantially outweighed by the danger of unfair prejudice to the defendant?
Then there's the problem of allowing the jury to replay a witness's video-recorded out-of-court statement in the jury room without the court's supervision. But a court can allow the jury to watch such a statement under its supervision. For example, telling the jury that it could only watch the video one time, and that it had to watch the video all the way through to avoid emphasizing any one part of it.
Turning to opening statements and closing arguments, what about the very delicate decision whether to intercede when opposing counsel does not object? On the one hand, you don't want to act like a backup attorney and offer objections, and sometimes an attorney has a real good reason not to object that you'll never know. But there are certain situations in which you may want to intervene. For example, our Supreme Court has held that a prosecutor's use of the words lie, lies, or liar when referring to the defendant's testimony or the testimony of a witness is improper. This is because the Supreme Court concluded that these words necessarily reflect the prosecutor's opinion, suggesting that the prosecutor's opinion is based on information that has not been presented to the jury. The words are also seen as inflammatory, which are likely to invoke strong and negative emotional reactions to the testimony of the defendant or of the witness.
Let's talk a little bit about jury instructions. Although some judges conduct instruction conferences off the record, you may want to ask yourself whether that's a good idea. Sometimes your ruling or counsel's arguments or counsel's concessions don't appear in the record if the conference was not recorded. Slowing down is a good thing. We understand that you have a jury waiting, but pushing too quickly to get going can result in important issues falling through the cracks. For example, is the presumption of innocence included? The burden of proof? Are the elemental instructions accurate? And don't forget that the new criminal jury instructions are available for you online.
Sentencing is complicated. As you know, the sentencing statutes take up about 200 pages in Title 18. So don't hesitate to ask both counsel and the probation department what they think the statutory limits on the sentence that you are about to impose. And when you are sentencing a defendant under the Sex Offender Lifetime Sentencing Act, remember that you need to set a determinate bottom-end sentence in addition to the indeterminate life sentence.
Two common problems pop up in restitution hearings. First, is there adequate documentation to support a victim's request? Look to the 2009 Court of Appeals case of People v. Dunlap that talks about what happens when you do not consider and set the defendant's restitution obligation. Second, was the prosecution's restitution request untimely? If the prosecution is not ready at the sentencing hearing for the court to set a specific restitution amount, it can ask the court to defer its order for up to 90 days. It can then ask for more time if it shows good cause to do so. But if it does not, and if the court does not set a restitution figure, then the court loses its statutory authority to do so.
Turning to post-conviction proceedings, When should a court grant a hearing, and when can a court resolve a criminal procedure 35C motion without a hearing? A court may deny a Rule 35C motion without a hearing if the motion, the case file, and the record clearly establish that the defendant is not entitled to relief, or when the motion alleges ineffective assistance of counsel, the motion's allegations of deficient performance are vague, conclusory, or lacking in detail.
This video is not designed to substitute for in-depth research about an issue, and you can obviously refer to other videos in this series to give you more information about those issues. This video is merely our effort to alert you to some issues that we see that may result in convictions being reversed. Thank you.
Thank you.